Friday, U.S. Marshals Ivanka Trump's passport. According to court documents filed Friday, February 6th, federal agents arrived at Ivanka Trump's Miami residence at 6:47 a.m. They left with her travel documents. $127 million, 23 shell. Company's 2 years of investigation and 1 2-hour testimony that nobody saw coming. I've been going through the filings, all 187 pages. What the headlines gave you surface level, what's actually in these documents, changes things. Melania Trump behind closed doors speaking under oath about her stepdaughter. The official transcript states she answered 147 questions, took 1 break, declined to invoke the 5th. This is where the case turned. Let me show you what happened. Quick context. Ivanka Trump, former senior White House advisor, daughter of Donald Trump, runs multiple business entities registered across 6 states. The issue, newly surfaced records, show a pattern of financial transactions that federal investigators allege constitute money laundering through a network of LLCs. Not my words. The indictment's timeline fast version: months ago, grand jury convened in Manhattan. Subpoenas went out. Ivanka's legal team started fighting document requests. Weeks ago, federal judge rejected her motion to quash, ordered full compliance. Days ago, everything changed. Melania walked into a federal building in Washington. 2 hours later, she walked out. The next morning, Marshals showed up at Ivanka's door. That sequence matters. Here's what I can tell you. Based on public disclosures, this investigation started. With the Trump Organization, it expanded. It found something in the family structure that prosecutors liked, and Melania, for whatever reason, decided to cooperate. That's the setup. The documents explain why. I went through them over the weekend 3 times, pulled the sections that matter. Let me break down what I found, okay? The evidence of first document filed Friday. I pulled page 43. It says, quoting here, defendant facilitated the transfer of funds from Trump Organization subsidiary accounts to a Delaware-registered LLC with no apparent legitimate business purpose. And that's not my take. That's the filing, what it means. Money moved. Where it went doesn't make sense on paper. But here's what got me. Page 89, different section. According to court documents between March 2023 and November 2024, Ivanka Trump's signature appeared on 31 separate wire transfer authorizations totaling $84.7 million. The destinations: a Cyprus holding company, a Cayman Islands subsidiary, a Nevada LLC that has no employees, no revenue, and no office. Put those together. Yeah, pattern. I went through this 3 times. The logic's clear. Money left Trump. Organization accounts routed through Ivanka's personal business network landed in entities that exist only on paper. It's all documented. It's pages 91,103. Now what nobody's covering. Exhibit F, buried on page 147. Verified financial records indicate Ivanka personally withdrew $3.2 million in cash equivalents over a 14-month period. The withdrawal pattern, never more than $9,500 at a time. Read that again, $9,500 repeatedly. Federal reporting threshold is $10,000. Under that, no automatic report. The filing calls this structuring. Prosecutors call it evidence of intent. Fallout. Passports seized pending trial. $15 million. Bone travel restricted to Southern District of New York within 72 hours. Of Melania's testimony. Now, here's the part that connects it. The official transcript states Melania told investigators she witnessed multiple conversations where Ivanka discussed keeping transactions below reporting thresholds. A direct quote from the filing, a witness Mount testified that defendant stated, "Keep it under 10, always under 10. That's page 156, paragraph 14. One more thing. Page 162. The prosecutors argue Ivanka had specialized knowledge of federal reporting requirements due to her role in the administration. They're not just saying she did it. They're saying she knew exactly what she was doing. Evidence summary: 31 wire transfers, $84.7 million. UH3 offshore entities with no operations. 89 structured withdrawals under $10,000. Testimony from a direct witness, pattern spanning 20 months. Legal analysts are saying this is one of the most documented money laundering cases involving a former White House official in recent history. Not one smoking gun, a whole warehouse of them, and it's all in public filings now. That's just the financial evidence, like the Melania testimony. It's its own thing. Subscribe. I'm going to break down what she actually said and why it matters more than the numbers. Story's developing. I'll stay on it, okay? But look, gotta be fair here. The other side has a point. Few points, actually. Constitutional conservatives say this is selective prosecution. We'll put a political hit job using the justice system. And honestly, some of it holds up. Their argument? First, the timing. This investigation ramped up right before election season. Coincidence? Maybe, maybe not. Second, the family dynamics using Melania's testimony against Ivanka. They argue that's coercive, that prosecutors pressured one family member to flip on another. Third, the structuring charge. Defense attorneys point out that withdrawing cash under $10,000 isn't automatically illegal. You have to prove intent. Alan Dershowitz, Harvard Law Professor Emeritus, put it this way. So, structuring requires proof of intent to evade. Patterns alone don't establish criminality, don't agree with all of it. So, but that's not nothing. What they've got no direct evidence of Ivanka knew about reporting laws from the transactions themselves. Melania's credibility as a witness, given family tensions. Precedent questions about prosecutorial overreach. Even Jonathan Turley, a constitutional law professor at George Washington University, admits this case raises serious questions about the use of family testimony and the timing of these charges. Look, I'm not here to tell you who's right. Prosecution's interpretation. The evidence supports money laundering, wire transfers, shell companies, structured withdrawals. Textbook case. Defense interpretation. Evidence of sloppy accounting, family. Business complexity and political targeting, not necessarily crime. Both readings exist. That's what makes this complicated. Here's what the defense filed Thursday. Official filings reveal Ivanka's attorneys argue the offshore entities had legitimate business purposes, including international licensing deals and brand management contracts. They submitted 47 pages of business records, contracts with foreign companies, revenue statements, their position. The money moved because the business moved. Nothing sinister. And they also attacked Melania's testimony directly. From the defense, motion, page 23. Witness Mount has significant personal and financial incentives to provide testimony favorable to the prosecution. Translation: Melania might have her own reasons to cooperate that have nothing to do with truth. Family dynamics are messy. Everyone covering this knows that. And here's the uncomfortable reality. Prosecutors have brought weak structuring cases. Before, they've lost. The law requires proving someone knew about the $10,000 threshold and deliberately structured transactions to avoid it. Knowing it happened isn't enough. It's a real legal hurdle. Defense attorney William Brennan, 37. Years of our federal criminal defense said the government needs more than a pattern. They need proof. She did this specifically to evade reporting. That's the fight ahead. What I can tell you what the documents show, and they show both sides have ammunition. The trial won't be a layup, but there's a reason the judge allowed passport seizure, a reason the bond is $15 million, a reason Melania's testimony happened behind closed doors instead of an open court. The prosecution thinks they've got something. It didn't come out of nowhere. Backstory quick. Over a year ago, the Manhattan DA's office expanded its investigation from the Trump Organization to individual family members. Subpoenas went out. Months ago, Ivanka fought every document request, privilege claims, executive immunity arguments, all rejected. Weeks ago, grand jury extended its term. That meant they weren't done. A source familiar with the investigation told reporters on record, we knew the probe had shifted to Ivanka specifically. The document requests got very targeted. What happened? The same thing that always happens when someone fights subpoenas. Investigators got curious, started pulling threads. Pattern delayed compliance with court orders, incomplete document productions, inconsistent statements from legal representatives every time, more scrutiny. The sealed indictment was filed. Weeks before Friday's arrest, prosecutors kept it under wraps. Waited? Why, Melania? According to court documents, prosecutors approached Melania in late January, offered a pro-for session. She accepted. That's when this case changed. Before her testimony, prosecutors had documents and bank records. After her testimony, they had context, motive. Direct witness statements about conversations that happened in private until Thursday. This was a paper case. Thursday made it human. One family member under oath for 2 hours talking about another family member. That's the context. Now you understand why Friday happened the way it did. See where this is going? The family angle is the whole story. Hit like if this is making sense. I know this is a lot of information, but understanding the context matters. Otherwise, you're just reading headlines like this. Friday, February 6th, 6:47 a.m. Eastern, according to court documents. For U.S. Marshals arrived at Ivanka, Trump's Star Island residence in Miami. They presented a court order, demanded her passport. Her attorney was on the phone within minutes. Made a call to the duty judge. Asked for an emergency stay? Denied. The court finds sufficient evidence of a flight risk given defendants' international business connections and access to private aviation. That's from the denial order filed at 8:12 a.m. Room for negotiation, none. What followed? Passport. Surrendered at 7:23 a.m. Bond hearing scheduled for that afternoon. $15 million secured by Friday evening. GPS monitoring fitted before she left the courthouse. For hours. That fast. Now what everyone missed. While media focused on the passport, something else happened. The court unsealed Exhibit G. That exhibit contains 67 pages of communications, emails, text messages, voice transcriptions. Then the judge did something unusual. She ordered Ivanka's legal team to surrender all devices used for business communications since 2021. Laptops, phones, cloud storage access. Compliance deadline, Wednesday, February 11th. Former U.S. Attorney Barbara McQuaid's response. She called it extraordinary. This wasn't reactive, calculated. You can see it in the sequencing. Thursday, Melania testifies. Friday morning, Marshals arrive. Friday afternoon, exhibits unsealed. Friday evening, device surrender ordered. Prosecutors weren't scrambling. They had a plan. And here's what's interesting. The device order came after the passport seizure, not before. That means prosecutors think there's more. They've got what Melania told them. Now they want to verify it against Ivanka's own communications. They're looking for deleted messages, encrypted conversations, anything that matches or contradicts what Melania said under oath. This is where the case either solidifies or falls apart. The devices will tell the story. Don't go anywhere. So what I show on next, why explains why this matters beyond the Trump family. Drop your prediction in the comments. Yeah. Think the device search finds something, or is this going to collapse? Keep watching. I'll give you my read. What are experts saying? Former federal prosecutor Renato Mariotti, 15 years with the DOJ. Passport seizure at this stage indicates prosecutors have strong evidence and genuine concern about flight. Plain English. They don't do this unless they're confident. Another, One former Assistant U.S. Attorney, Daniel Goldman, the Melanian testimony is the linchpin. Family witnesses are incredibly powerful and incredibly rare. Key there. Family members almost never cooperate. When they do, juries pay attention. Here's what's interesting. Even former Trump attorney Tim Parleratores admits the structuring allegations are serious. If the pattern is as documented as the filing suggests, the defense has real work to do. When both sides agree on the seriousness, pay attention. Consensus from legal analysts. The evidence volume is unusual for this stage. Melania's cooperation changes the dynamic entirely. Device surrender order suggests prosecutors expect more. Passport seizure indicates high confidence. That's where professionals land. But there's disagreement too. Criminal defense attorney Carolyn Policy, former federal law clerk, structuring cases are notoriously difficult to prove. The intent element is where prosecutors often stumble. Constitutional law professor Elia Shapiro added, "We should be cautious about celebrating prosecutions of political figures. The precedent matters." Valid points. Here's my read after going through everything. The prosecution has volume, documents, witnesses, patterns. The defense has complexity, legitimate business, arguments, family bias claims, intent questions. What neither side has certainty. This isn't a slam dunk despite the headlines. But the passport seizure tells you something. Judges don't order that lightly. They looked at the evidence and decided Ivanka Trump might run. That's not a neutral signal. Former DOJ official Harry Litman put it simply, flight risk determinations require probable cause. The judge saw enough to believe she might leave. Courts don't guess, they assess. Useful breakdown, hit like. I know these scripts take time to watch. The like button actually helps the algorithm push this to people following the case. Use it if this is helping you understand what's happening. Why should you care? Real talk? How this affects actual people. Money. If you own stocks in any Trump-affiliated business, pay attention. Trump Media stock dropped 12% Friday. Trump Organization bond prices fell 8% by market close. The financial contagion is real. Legal uncertainty does that. Your portfolio might be exposed without you knowing. Index funds, RITs, banking sector holdings, what some investors are doing. Reviewing exposure to politically sensitive assets. Talking to advisors about rebalancing. Not advice. Just what I'm seeing in the financial press precedent. This sets a precedent. Next time you're in a business dispute or, God forbid, a legal matter, rules about family testimony apply differently. Quick example. Just your spouse knows something about your finances. Your adult children were present during a conversation. Under current law, prosecutors can approach them, offer immunity, ask them to testify. This case shows they will. Not dramatic. That's how this works. The spousal privilege protects married couples from being forced to testify. But Melania wasn't forced. She agreed. And stepchildren, no privilege at all. Who's affected right now? According to court documents, investigation has identified 23 individuals who received funds from the shell company network. Business associates, contractors, consultants. Some already lawyered up. Others reportedly cooperating. Hits everyone. In that orbit, what nobody wants to say, uncomfortable part? If you've ever structured transactions to avoid reporting requirements, you're watching your playbook get prosecuted. Small business owners, real estate investors, cash-heavy businesses. The government is using this case to send a message, not just about the Trumps, about everyone who thinks transaction thresholds are suggestions. If you've kept withdrawals under $10,000 intentionally, you're part of this conversation whether you like it or not. Not trying to scare you. That's what the legal landscape suggests. Practical, what informed people are doing. reviewing transaction histories with accountants, documenting legitimate business purposes for cash movements, asking financial advisors, "Am I exposed?" Knowledge helps. The IRS has increased structuring enforcement 340% since 2020. This case is the highest profile example. But not the only one. If you run a business that handles cash, this matters. If you've ever split a large purchase into smaller transactions, this matters. Consult a professional, understand the rules. Bigger picture. What happens to Ivanka Trump will influence how prosecutors nationwide approach high-profile financial cases. Win here, they get aggressive everywhere. Lose here, defense attorneys have a roadmap. Either way, the rules of engagement are being written right now. And you're watching how Ivanka respond made it worse. Honestly, within hours of the passport seizure, her team released a statement calling the prosecution politically motivated persecution. Quote, "This is a weaponization of justice against the Trump family that every American should fear." Reaction statement shared 2.4 million times on social media. Fundraising emails went out within 30 minutes. Prosecutors came back through a spokesperson. The evidence speaks for itself. This office doesn't comment on political rhetoric. Then the judge issued an unusual order. She prohibited both sides from making public statements that could prejudice the jury pool going forward. Partial gag order, effective immediately. And that means Ivanka can't keep doing the media circuit, can't keep calling this political, can't fundraise off the case directly. Her team pushed back, filed an emergency appeal Sunday night. Denied this morning, the order stands. So now she's restricted. Can't travel internationally. Can't talk publicly about the case. Can't leave Southern District of New York. Without court permission, from running international businesses last month to GPS-monitored movement this week. Not cooling down, heating up. The defense filed 3 motions Saturday challenging the passport seizure, challenging the gag order, challenging the device surrender timeline, all pending. Judge's response expected by Wednesday. What's still unclear? 1. What exactly did Melania say? The transcript is partially sealed. We have excerpts from prosecutors' filings, not the full 2 hours. 2. Why did Melania cooperate? No immunity. Deal has been disclosed. No charges against her referenced. She walked in voluntarily. That doesn't happen without a reason coming. Federal court has a status conference scheduled Wednesday, February 11th. Ivanka's team is expected to argue for modification of travel restrictions. Prosecutors reportedly preparing additional exhibits for the court. Date to watch, Friday, February 13th. That's the device compliance deadline. Whatever's on those laptops and phones becomes part of the evidence record. If there are deleted messages, forensics will find them. If encrypted apps were used, prosecutors will know. If the communications match Melania's testimony, case strengthens. If they don't, defense has ammunition. Friday is the inflection point. Should know more by then. Also coming, grand jury reconvenes Thursday, February 12th. Additional charges remain possible. The indictment we've seen might not be the final version. Subscribe. I'll cover the Wednesday hearing and a Friday deadline. This story is moving fast. Multiple developments expected this week alone. Hit subscribe, turn on notifications. When the next filing drops, I'll break it down the same way. Where we are right now, Ivanka Trump passport seized, $15 million bond GPS monitoring active. Melania Trump testimony complete. No charges filed against her. Device surrender ordered. Deadline Wednesday, February 11th. Trial date not yet set. Additional charges. Possible grand jury reconvening. Thursday scheduled. Wednesday, February 11th. Status conference defense motions hearing. Thursday, February 12th. Grand jury session. Friday, February 13th. Device compliance deadline. Monday, February 16th. Expected prosecution response to defense motions. Not public yet. Full Melania testimony transcript. Defense witness list. Potential cooperation agreements with other subjects. Clocks running. The defense has for days to turn over those devices. 4 days to win modifications on the gag order. 4 days before the grand jury potentially adds charges. Meanwhile, prosecutors have what they need to proceed. They're not waiting. This case moved. Faster in 5 days than some cases move in 5 months. That's intentional. When you seize a passport, you're telling everyone, including the defendant, that you're serious. They're serious. That's where we are. Ivanka Trump restricted, monitored, fighting on multiple fronts. Surface Reed, former White House advisor, facing serious federal charges, but Melania's role remains the real story. Why she cooperated, what she actually said, whether it holds up. The device surrender will tell us whether prosecutors have corroboration or just testimony. I'll be watching Wednesday's hearing. The judge's tone matters. How she handles the defense motion signals where this is heading. Story's not over. Still developing. What we know, the evidence is substantial. The family dynamic is, unprecedented. The legal strategy from both sides is aggressive. What we don't know whether any of this results in conviction. Cases like this have collapsed before. High-profile targets, political pressure, an aggressive prosecution that couldn't close. This one might be different. The documentation is unusual. The witness is unprecedented. But we're in Chapter 2 of a long book. Subscribe for the full picture, not just headlines. When documents drop, I'll break them down. When the Wednesday hearing happens, I'll have the analysis. Stay informed. Talk soon.